What if I told you that a US federal court just gave a judgment that an AI company can train its AI chatbot on millions of copyrighted books without permission from the authors or without even compensating them and still receive the protection of the law? Your mind would be blown, wouldn't it? Well, it actually happened in the most recent Anthropic's case. Anthropic, they're the owners of Claude, but anyways, we'll get down to that. Hi guys, I'm Nneoma Grace, a corporate and tech lawyer. Welcome back to my channel, and today we are going to be diving deep into Anthropic's case, which is shaking the legal and the creative world. So Anthropic has been in the news for the past couple weeks because a judgment was given by US Federal Judge William Aesop in their favor. Now this judgment read that Anthropic's use of millions of copyrighted books to train its AI chatbot Claude was transformative and indeed fair use. Now the implication of this judgment is that AI companies can use your copyrighted works to train their AI chatbots as long as it's transformative and fair use. Now, as you can clearly see, this judgment has massive implications for the legal industry, for the creative industry, for the AI technology industry as well. But we're getting ahead of ourselves. How did we get here? What is the genesis of this case and all that surrounds it that led up to this judgment? Anthropic is an AI software firm. They are the owners of the AI chatbot Claude, and they are founded by former employees of OpenAI, the pioneers of ChatGPT. Now, Anthropic has been in the market for years now, literally. And to give us Claude, they needed to have trained Claude on millions and, Claude and other large language models on millions and millions of books and other resources. Now, how did they do that? They did two things. First of all, they purchased used copies of books from, wherever they purchased it from. Used copies of books. They purchased those copies. Good, beautiful. The law doesn't frown at that. Then the second thing that they did was they downloaded millions of copies of books from pirate websites. So that means they downloaded them free of charge from pirate websites, meaning that they had no right to even download them, much less use them for the purposes that they did. Now, in order to make trainable data from books, that particular book has to go through several processes. The first thing is that each book has to be digitized in one way or the other. So that means the bindings of the book has to be torn away. So the identifiers of the book, identifying the owners, the copyright works, and all that beautiful details have to be torn away. So the bindings will be turned away. The pages of the books will be trimmed down into a size that is scannable. Now, once they scan these millions and millions and millions of copies of books, I think the case said a total about 7 million copies of books. But anyways, once they're done scanning these books, now they have digitized it. And once they digitize it, they tokenize it. Token is when you kind of like, you compress it into a way that is readable for the AI machine or for the large language model, and they then dispose of the actual paper copies of the books. Now, this is what they did to all 7 million plus copies of books. Now, amongst these many books were obviously copyrighted works, and some of the authors, including Andrea Bartz, Charles Graeber, and Kirk Wallace Johnson, brought a putative class action against Anthropic. Now, a putative class action is when most of the plaintiffs are known, and those people or those plaintiffs who are known then file a class action to represent both themselves and a potential group of people who might have been slighted by the same offense. But that's an aside. Now, these authors, they brought this class action against Anthropic. First of all, Anthropic got a hold of their books, downloaded their books from pirate websites without permission from them, without compensating them for anything, got a hold of their books, now used their books or destroyed their books in a bid to train their large language models. And, again, like I said earlier, in order to make trainable data, you have to digitize the books. And in the process of that digitization, the books can get destroyed in the process. Now, that was part of their grievance or their anger with Anthropic, that first of all, they got the books without their permission and without compensating them. Then they proceeded to destroy it, and then they proceeded to, after destroying it, or even before destroying it, whatever, but then they proceeded to keep it forever in a central library that Anthropic is creating of all the books in the world, in quotes. Now they brought this action against Anthropic and laid all of their evidence, all of their, grievances and all of their prayers before the court, and it was time for the court to decide. Now, what did the court decide? Before the court obviously reached its judgment, Anthropic was allowed, per fair hearing, to bring its own defense to this suit that has been brought against them. And they did something very, very smart. They brought a defense of fair use, that their use of these millions of copies of works was for fair use. Their use of it was transformative in the sense that when you impute a prompt to Claude, their pioneer AI, it wouldn't spit back the book to you, but it would spit back a response that is kind of like from the book, but not necessarily off the book. Does that make sense? So they said that their defense was that their use of the book was necessary to train their AI. And what the AI eventually ended up doing with it was quite transformative. And, you have used Claude, you have used ChatGPT, you can testify of the results you get when you impute a prompt to them. And the judge actually agreed with Anthropic that their use of the millions of copyrighted works, including those they downloaded from pirate sites and those they purchased, used copies of, was actually transformative and indeed fair use, because their use of those works was necessary to train the AI. And if you impute a prompt to the AI, you would not get the book back. The book, you wouldn't even know it's coming from that specific book, because it's an amalgamation of so many other works. So therefore, their use of it was transformative. On to the second grievance by the people that, hey, you got these paper copies of our books and you have digitized them and disposed of them, and we are mad about that. The court was like, yes, even the digitization of the books was actually indeed necessary to make it into trainable data that the AI can use. And it was indeed fair use, because all that Anthropic did was to carry the paper copies and to turn them into digital copies of the actual work, essentially compressing it and making it such that the AI can consume it and others can consume it as it's needed digitally. More so, it was fair use because no new copies were made, nothing new was added to the book or subtracted from the book. The content of the book remained the same. All that happened was it was transformed from a physical copy to a digital copy. And so therefore, the digitization of the books is fair use. The court also said that Anthropic's storing of the books in a central library or its disposing of them is indeed fair use. Now, this decision was split right in the middle because, again, remember, there were the copies that were downloaded from pirate sites, and then there were the copies that were purchased from, used books. Now, the court said that the use or the adding of the purchased books to a central library and its disposal thereof is Anthropic's right, in quotes, because now Anthropic purchased the books, so it has the right to do with it whatever it so pleases because it purchased the books. Now, for the downloaded copies, on the other hand, what Anthropic did was illegal because, number one, they had no right to use the books. They didn't buy them. They didn't get the authority from the owner. They didn't compensate the owner in any way. So why would they then download books from a pirate website and then dispose of them, store them in a central library, or alter them in any which way? So that was where the decision of the court split, because every other thing thus far, the court was saying, oh, we're good to go. It's, fair use and all that. So now what is fair use? I mean, you've been hearing me use this word. In fact, it was the crux of this judgment: fair use, transformative use. What is fair use? Fair use is a defense of sorts in copyright law that is used primarily in the United States, and it's backed by the Copyright Act, specifically Section 107. Now, fair use, again, is where you don't necessarily, is a defense, as I said earlier on, and you don't necessarily need the permission of the owner of that work to use it, provided that you're only going to critique it, you're only going to make comment on it. You're not going to make any money from, your usage of that work. You're not going to create a derivative work from it. You're not going to sell it, share it, modify it, or in any way tamper with the originality of the work. You are simply critiquing, making comments, and for educational purposes only. And for something to qualify as fair use, it has to go through 4 criteria. Number 1 is the purpose and the nature of that book. It has to be for a non-profit use. It can't be for a commercial purpose. Number 2 is the nature of the copyrighted work. Number 3 is the amount and the substance of the copyrighted work being used for whatever purpose that would then, make it qualify for fair use. Number 4 is the effect of the use upon a potential market or upon the potential market. Now, when the judge looked at these 4 qualifiers, or fair use qualifiers, this was the opinion of the judge. Number 1, the purpose and the character of the work, of the use of the work. The judge, as I said earlier on, agreed that the work was transformative and indeed fair use on that ground because number 1, the AI did not make any new work. It didn't reproduce the work in any way. It didn't regurgitate the work in any way. Even when you type in a prompt, it wouldn't vomit or regurgitate, like I said, the work to you as it is in the book. It would reconfigure it, make it in an entirely new way that does not detract from the original work. And so therefore, the character of AI, of Claude's use of the work was transformative, and indeed it was then fair use. More so, the conversion of the works from print to digital was also, again, the character of the use of the work was fair use and transformative because, again, it did not make any new copies. It didn't recreate the work in any other way. It simply just transformed it from print to digital. Now, the second criteria for fair use, the court actually did not agree, which is the nature of the copyrighted work. In this case, there were books, and the law didn't quite agree, especially because of the ones that were downloaded. The law didn't quite agree that, fair use applied in that particular instance. Now, the third one, the amount and the substantiality of the work used. AI needs billions and billions and billions of words and resources in order to train it to give us the output that it gives us. And so therefore, in that instance, fair use favors it. However, for the copies that were downloaded from pirate websites, Anthropic had no right to even use those words. They had no right to use those books that were not legally gotten. And so therefore, fair use did not favor them in that instance. Now, the fourth one is the effect of that particular usage on the potential market. Now, this is where it gets a bit dicey. The authors argue that Anthropic's use of their work robbed them of the right or of the ability or even of the opportunity to charge a licensing fee for their works to be used as trainable data. But the court said no, that is not even a market. The ability to license your work as trainable data for an AI to use is not a market. So, and the law kind of precludes you from doing that. So you cannot hinge. Now, this was the cost to the authors. So you cannot hinge a grievance on a market that does not exist. Besides, doing that will cost Anthropic more than it stood to gain from, because you didn't think about it. Imagine, again, they had 7 million plus copies of books. Imagine having to pay each and every author a percentage for the books that that they're going to use to train their AI. It would cost them a whole lot more than they stand to gain. And the court did not favor the authors in that regard because, again, the market does not exist. So they can't even have a grievance for a market that does not exist. And Anthropic would lose more than it stood to gain if they followed that route. Therefore, on the topic or on the issue of fair use, the court sided with Anthropic that number 1, their use of the works were transformative and indeed fair use. However, this judgment only applied to the purchased copies of the books. The downloaded copies of the books, the law absolutely frowned upon it and said no. The fact that you downloaded pirate copies of these books was illegal and you had no right to, first of all, keep them in a central library, and 2, use them and dispose of them. You don't have that right. Now, what about the other issues in this case? What right does Anthropic have to digitize the books? Well, if they purchased it, then they have the right to do with it as they desire. The only issue is they didn't purchase some of the books, and so therefore it's illegal on that end. Another issue now is, so what exactly now is the line between transformative use and copyright infringement? Because throughout this case, you hear the word transformative use, fair use, transformation, going round and round. But where is the line drawn between transformative use and copyright infringement? And unfortunately, it's a very subjective matter, because what is transformative use to me, based on the provisions of the law that is, might be different to another judge, or in a different circumstance, or in a different set of facts that precede that particular situation. And so it's up to the judge to decide what is subjective, obviously within the bounds of the law, yes, but the facts surrounding the case and the law will ultimately decide. And I think that this is one defense, transformative use, fair use, is one defense that a lot of AI tech companies will use in their arguments in favor of whatever case they are bringing. But in all this, what is my legal opinion? Well, Anthropic's win in this particular case is a double-edged precedent, because on the one hand, now the judge has given AI companies an out to use, works as they desire, provided they purchase it, obviously. They purchase it from the right angle and they use it. They've given them the right to use it without permission from the authors and without further compensation, provided that, again, they purchased it initially. But at the same time, too, it has entirely ended a market that could have emerged from this, which is the licensing of these works as trainable data. It had ended the market. But then, should that market even be allowed to exist? Some people will argue, yes, the market should be allowed to exist. But I mean, if they've purchased it, again, now I'm talking directly from the law, right? From the angle of the law. If they've purchased these books, now they have the right to do with it as they desire, by virtue of Section 109 of the Copyright Act in the US, but also by virtue of the doctrine of first sale. Because once you have rightfully acquired something from the copyright owner, it then automatically belongs to you, and you can then do with that particular copy that you have acquired as you desire. More so, it normalizes the use of copyrighted works without consent. But again, first sale, and once you've acquired it, it's now yours to do it as you desire. So, but like I said earlier, it's a double-edged sword either way. Because on the one hand, it favors the tech companies. On the others, it doesn't really look very good for creators. I would have to say. It doesn't bode well for creators, especially with those two defenses at play. So I believe that, all that's being said, this entire case and everything that surrounds it, it just tells us that we need to understand, we need to go back to the history books and we need to study history. How did we get here? Okay, let's actually think about it for a minute. At some point in time, music was being sold as CD records, but now we have them on streaming apps. Movies, we had to go someplace and rent a movie. Now we have them on streaming platforms. And it's working in some way. You don't find people complaining that, streaming platforms took away their movies without permission or compensation to them. How were we able to get here? And how can authors of books and other training data or trainable data get to that point that we are with music and movies? And that's what we'll discuss in our next video, the doctrine of first sale and how streaming platforms, internet giants, became what they are today. So until then, guys, I will see you later. I hope you learned something in this video, and I hope you now understand the fragility of the world that we're living in, especially with things like copyright and artificial intelligence, and how you must take proactive steps to register your work. It's not enough, yes, copyright in yours automatically, I understand that, but you also need to register your work so that you have some sort of rights to them. You also need to take appropriate technical or technological steps to protect your work. For instance, having them encrypted in one way or the other, infusing them with metadata that makes it easily recognizable as yours, and a whole bunch of other protective measures you can take. Now, if you found this video helpful, please don't forget to hit the subscribe button so that this video will be shared to as many awesome people just as yourself. Until next time, guys, bye.